Welcome to everybody in the room. Welcome to everybody who's online. Sorry we're running a bit late. It's the way of MOJ ministers that they turn up late to this conference. But very useful and interesting comments, I think, made by the minister, and helpful and positive road that the minister is suggesting they're going to travel. I was just saying to Tessa here that I put down some of the key things she said, and I think effectiveness and fairness is something that we really want to take on board on the enforcement field. As the Master of the Rolls mentioned, this has been an area which has been put in the too difficult to handle box for a very long time. Now I'm looking at it, I absolutely understand why it's been in the too difficult to handle box for too long a time. When I was asked to chair a working group with regard to this, I have to say I didn't think, oh, enforcement, that's exciting. But then I thought about it a bit more, and I thought actually it is the fundamental, really, in our civil justice system, in that there's no point in somebody spending a lot of money going to court in order to enforce their rights when those rights are talking about money judgment, if at the end of it they can't enforce it. And at the same time, it's absolutely essential that the people who are at the wrong end of such a judgment are given the protections that they need and deserve in order to ensure that they are not put in a position that they should not be in. And of course, one of the things that comes across very clearly with enforcement is the distinction between those people who can pay but won't pay and those people who can't pay. And one of the issues that we're very conscious of is continuing with the protections for those who can't pay, whilst at the same time making the system more efficient and fair for those who are seeking to enforce their rights. Now, as has been mentioned this morning, and I'll just mention it again because it's always a good touchstone to come back to, is that the purpose of the Civil Justice Council and its statutory obligation is to keep the civil justice system under review and to consider how to make the civil justice system more accessible. And in doing so, we are able to make recommendations to the Lord Chancellor, the Judiciary and the Civil Procedure Rules Committee. And it seems to me that in this work on enforcement, we're going to be making recommendations to all. We know that the enforcement of judgments is currently working in a less than optimal way. And indeed, we have had comments back about it being archaic, Jurassic, and other such words. It is mired in difficulty for anybody who wishes to enforce a judgment, and it fills people with fear if they are, as I say, on the wrong end of a judgment. And what we want to look at is how to make all of that system more accessible, fairer and more efficient. Now, the working group that are together on this include people who work within the justice system. So myself, David Robinson, who was then a district judge, and the Chief Master of the King's Bench Division. We also have solicitors. We have David Parkin from enforcement. We have the Enforcement Control Board. We have the High Court enforcement officers represented. We also have representatives from debtor advice. So we have tried to cover across the field. But most important, I think, has been the call for evidence, which has got a very good response. We've had 45 individual responses, but those individual responses in many cases cover a large number of groups. So they've combined together, and they have given us the best evidence available as to what it is like out there. There are some areas where there is agreement. Not surprisingly, most people are agreed that there needs to be better information, forms need to be clearer, there needs to be earlier advice given, and we need to concentrate on alternative methods. Indeed, as the Minister was saying this morning, taking things out of the court, dealing with them through mediation and alternative dispute resolution are all positive ways forward. What I would like to see is just greater communication from the two sides of enforcement so that there can be a more efficient way forward. There is also, not surprisingly, a great deal of dispute as to how enforcement should take place. And there are certain areas where it is going to be an issue of how do you square the circle. Plainly, those who have a debt they wish enforced want that dealt with as quickly as possible and for as cheap a cost. That is something we would like to work towards. Those who are facing a judgment debt, as I say, need to ensure that they still have the protections. And those two areas do collide. One of the areas that we may look towards is potentially not having a split system of enforcement. But that is a big issue and needs a lot of discussion and thought. There's also the issue with regard to default judgments. An enormous amount of judgments are entered in default, and we can see that the means of setting aside default judgments is unwieldy, costly, time-consuming, and practically very difficult. Lots of cases of people who have a judgment in default against them, they knew nothing about it, their last known address was one they had lived in many years before, judgments entered, they suddenly find out they have a judgment against them when they try and apply for a mortgage, and they can't get it, and then they can't get the judgment set aside in order to clear their name. Those are all problems. They are, in my view, things that we can properly work towards and fix. Now, having done a sort of general overview of where we are, I'm very grateful that Tessa's up here with me. She's a sort of not a member of the working group, although she's listed on the working group because she's here from the MOJ and obviously as an observer because we may well be making recommendations in due course. But it is an indication of how importantly the Ministry of Justice look at this work and how we can work forward on it. What I'd really like today, and obviously I can take questions and answer as best I can from what we have seen from our call for evidence, is to really have a discussion with you who work in this area as to what you would like to see happen, how you think it could happen, and generate a general discussion in this room as to points that I can then take back and work into the other evidence that we have already received. So over to you. There is a microphone. Brilliant. Thank you. It's always the brave person who starts off.
Thank you. Judy Gibson, I'm a district judge in Hereford and Worcester, and I do a lot of small claims work. And I'm aware, of course, at that point, at the end of the hearing, where the claimant has been successful, has got their judgment, and of course they ask what to do next. So you're quite right that more accessible information is important. I would put in a plea. I don't think I'm naive enough to believe that enforcement could become free, but at the moment, there seems to be a court fee for every type of enforcement that you take. Could there be a single fee that opens up the whole range of enforcement for somebody who holds a judgment? My second plea is the updating of court forms. So there are defence and admission forms, including in possession cases, that still refer to completely outdated benefits. So, defendants are asked for information that is irrelevant and out of date.
Yes, and can I just ask? I mean, moving on from that, the forms, because forms are ridiculous. I mean, I find this. I filled in a form, for a court funds office, and they ask you the name of the claimant, and the claimant is always so and so as litigation friend for so and so, inevitably, and the box is this big, and you just think, why did somebody do that? With forms, do you think it would be worthwhile having some sort of program where you say, well, actually, every 12 months, 24 months, they are reviewed and looked at again, rather than we do it once and that's it?
I suppose that's one approach. The other thing is to categorize what feeds into the forms so that changes in, for example, benefit structures would trigger a change to some of the court forms. If our small claims were not taking so long, one suggestion would be that whether somebody defends a claim or admits it, that they have to provide financial information as part of the defence. But unfortunately, with small claims taking so long, that information is likely to be out of date by the time we get to a final hearing. But that would enable a judge to perhaps give a little bit more of a steer about the options, because it would provide similar information to the old days of an oral exam.
Well, I think one of the things that we're thinking about, and it's been suggested by people in the debt advice field, is to actually use the standard financial form that a lot of debt advisory agencies use, because it's much more detailed than is on any form. And it seems to me that if we could say that goes out as soon as any claim goes out to someone and it's filled in then, that doesn't mean that if you get to court, you can't fill in another one and say, well, actually, I need to update that. And, my circumstances have changed and I'm actually much worse off now than I was then. But certainly, I think that is part of the improving the communications between the parties. So I think that's very helpful. Thank you very much for that.
Can I just add one final thing, which is the challenge for bailiffs. So in my area of the country, there is a particular group of freemen of the land who call themselves Hereford Common Law. And there is basically, whether you're a bailiff or a High Court enforcement officer, you don't go in to enforce against one of their members without a police presence. So I think there just needs to be an awareness of, actually at the extreme, what the challenges are of enforcing court judgments, and that is relevant to possession orders, of course.
Yes, thank you. I should say, possession is not something we are looking at the moment. We probably will. But we realised at the time when we started that there was likely to be changes coming down the track, and we didn't want to start something that then changed. I agree entirely the point of protection of those who go to enforce. I had an incident a couple of years ago where a county court bailiff actually enforcing possession had a kettle of boiling hot water over his head. I mean, you know, very nasty. And of course, that is a complete affront to the rule of law. So I agree. Something for us to mention. Thank you. Yes. Okay. Well, let me take one in the room, blue jumper, because I saw that first. One online, and then you next, and then you next, if that's all right.
Super, thank you. My name's Paul Yates. I run the pro bono practice at Freshfields. We do some county court enforcement cases for trafficking survivors who've been through the employment tribunal, and I struggle to see how the system could be navigable for somebody without a lot of help. I agree with what's been said about the need for more information, and my question is whether any consideration is being given to Part 4 of the Tribunal Courts and Enforcement Act 2007, which is the information, particularly the information orders and information applications piece, because that is sitting there on the statute book.
Yep.
And would, in my view, be very helpful, but I don't know if there are plans to use it.
We are certainly thinking about it, if that helps. I mean, it's I think it may well be something that will be part of suggestions we make, that it's looked at.
Okay.
Because as you say, it's sitting there. One of the things that we looked at when we started this work, and I have spoken to an academic in Cardiff who's done a lot of work on, you know, in comparison between this jurisdiction and European jurisdictions on enforcement. Some jurisdictions, such as Sweden, have a complete open book that you know everything about everyone, which is good for some and not good for others. Mm-hmm. The fact that we've actually got something in place is actually really helpful. So yes, thank you. But I agree also, lots of information. I mean, the problem with everything like this is it's going to take money to make it work better. But if we can make it work better, then that money will be very well invested, because it will free up in the way that the minister says, want things freed up. So yeah, thank you. I'll go online.
Morning, and thank you, Chair. I'm Jodie Berg. I chair the National Residential Landlords Association, and I previously chaired the Administrative Justice Forum. So these are matters that are very close to my heart. Apart from the delays that there are in getting a possession case into court, one of the major concerns for landlords is the length of time it's going to take for bailiffs to enforce a court order. And that length of time can be anything up to a year plus, which is a lot of lost rent and a lot of lost business opportunity for landlords. And one of the reasons why there is that delay, we are told, is not just the lack of bailiff staff, but also the lack of safety equipment for those staff. And the net result of that is that they daren't go out to try and enforce an order because they simply don't have the right kind of physical equipment to keep them safe when they're there. So you're quite right, Chair, we absolutely need more investment, but it's not just investment in staff, but also investment in the equipment that staff need to enable them to do the job.
Yes, thank you. Point well made. The MOJ are here. I'm sure they're hearing. If it's down to them. Yes.
Hi there. So I'm Joseph Wright. I'm a solicitor. I do a lot of housing work, and a fair part of considerable part of my work involves supporting gypsy and traveller communities who are faced with possession proceedings and eviction. Now, in 2017, there was a consultation on aligning enforcement procedures between the High Court and the County Court. Because previously, High Court enforcement officers didn't provide notice of eviction to anyone, Ultimately, the law was changed, but there was an exclusion. So basically, High Court enforcement officers have to give everyone notice of eviction, but people who entered or remained as trespassers were excluded. And I think the rationale behind that was not wanting to give people who have no civil law right to remain in the property extra time, so not to delay the eviction process. But the difficulty is that that's now been interpreted by the vast majority, I think, of High Court enforcement officers as meaning that they just don't provide any form of notice whatsoever, even where doing so wouldn't in any way delay the eviction. So you've got extremely vulnerable communities who are repeatedly being subject to completely unnecessary trauma and being sort of woken up, basically waiting on the knock and then being woken up in the early hours of the morning. And I regularly see clients who are suffering from things like PTSD as a result of this. And essentially what we're saying is there should be some kind of change in the rules so that even though people shouldn't be given any specific period of notice, because the eviction essentially shouldn't be delayed, where it wouldn't delay the eviction, High Court bailiffs should be giving as much notice as possible, in the same way that the county court do. County courts generally, once an eviction is booked, they'll send the notice out. There's a number of other issues, for example, the fact that under Part 83 of the Civil Procedure Rules, both claimants and defendants have a right to send a notice to the High Court enforcement officer requesting reasonable information about the execution of the writ. And that's quite important because if a person's out and their belongings left in the property, they need to be able to get information about what's happened so they can get their property back. That's not possible for defendants because no eviction notice whatsoever is provided. Defendants have no idea which company or organisation it is that's carried out this eviction. There's a complete lacuna in terms of the accountability of the private sector enforcement agents who ultimately attend these evictions, because defendants don't know who's done this, including in sort of where you've had instances of violence or abuse during evictions. Really, there should be some form of notice of eviction, even if it doesn't give the defendants anything more than a day or two, or even any extra time at all. But there should be a notice, in our view.
Okay. Working group on enforcement is not, in fact, dealing with possession. I mean, it is useful, of course, to know the entire landscape. I think, is David Parkin in the room?
Yes.
Is there? I mean, is that something that you've done with your work? Have looked at enforcement with regards to travelling community squatters, or is that not something?
Potentially, sorry.
It might be. Sorry, can you? Sorry,
yeah.
Better introduce yourself.
Sorry. Yeah, I'm David Parker of the Enforcement Conduct Board. I may give a disappointing answer, I'm afraid. At the moment, the ECB is the oversight body for enforcement, but at the moment looks at only debts under taking control of goods, so council tax, business to business, parking, things like that. It doesn't yet. I'm not saying into the future, but it may be well into the future. It doesn't yet have in its ambit, and it's not a statutory body either, it doesn't have enforcement of possession.
Right. Okay. I think Steve from the MOJ might be able to say. Oh, sorry.
Hi, sorry, I'm Stephen Jarman, Deputy Director for Civil Justice and Law Policy at the MOJ, and I just thought it might be helpful for some of the rationale of when the Ministry commissioned or asked the CJC to pick up this work, the rationale for focusing on monetary claims and not possession. Part of that came from the landscape of housing law is about to change quite significantly with the Renters' Rights Act, and there's a significant amount of work that's going into looking at the implementation of those provisions with HHJ. So we require quite substantial rule changes, quite substantial operational delivery changes, and a move towards more digital systems. What we thought would be unhelpful on that is, giving a slight hospital pass to the enforcement working group, saying, well, can you advise on this when there is so much change coming down the line? I think what is really helpful to hear is to hear these, and rest assured we're capturing them, so that as we are looking at reforms flowing from the Renters' Rights Bill, and actually in the longer term, that we can turn our attention to know. So certainly really helpful to hear those contributions. But given the significant change, I think they're going to be on the kind of next wave rather than this wave. Thanks. So I hope that was helpful, Karen.
No, that's very helpful. Thank you. Who was next? I think you were next with a pin up. Thank you.
My name is Carlos Tabazias. I'm a retired district judge. And some years ago, I got, as part of the European Judicial Training Network, I got to sit in first instance court in Spain for some time. And the system, it might not be at all applicable directly here, but each first instance judge has what's called a judicial secretary, who's legally qualified. And one of the primary responsibilities of the judicial secretary is enforcement. And what that does is it concentrates all means of enforcement in the hands of one person, so that whether attachment of earnings, third-party debt order, charging order, whatever is most appropriate can be determined by one person, and various means of enforcement can be employed simultaneously. It also, the court is also in Spain under a positive duty to assist in enforcement. So the court may itself, I've seen judicial secretary writing to 6 banks saying, by the way, is there an account here? If there is, better freeze it. Now, of course, in a sense, these are all interim orders in the sense that you can object to them. The defendant can object to any of them. But it does put a much higher priority on enforcement and centralize its efficiency. I'm not suggesting that's immediately applicable here, but I think it's something that might be looked at. For example, having a designated court officer with overall responsibility for enforcement. The other advantage, of course, of the Spanish system is that because it's the secretary of the particular judge, enforcement then gets relayed back to the judge, and there's a feedback on enforcement. But anyway, it simply as an observation, you mentioned differences in other jurisdictions, and that's quite a striking one.
Yeah, no, I mean, that's actually very helpful. I mean, we're always mindful, of course, of what is possible. I think, I mean, that's a very good system because you've also, as you say, you've got judicial oversight and pushing, and no doubt the judge sits there and says, well, I didn't go through all that and make that judgment to find that nothing's going to come from it. So that's good. I mean, there is also the example in Singapore that there is a sole sheriff who will take on and do the same thing and will decide what is the best way of enforcing judgment, because that does seem to be a real problem here, that people start and they don't know where to start. They have to issue a new application for each type of enforcement, and will go down the end of the line and then find, well, actually they're getting nothing at the end. So that's helpful. Thank you. I think Daniel, you were next.
Yeah, I'm Daniel. I'm a barrister in independent practice. This is just a thought that comes out of some work that I did previously in relation to breathing space and mental health moratoria. I know that there's a review. I think there's a statutory obligation on I think it's the Treasury have to review that, and that's coming up in the next. You'll know better than I do, 18 months or something like that. I don't know how far the working group is already considering. I mean, I only have a relatively passing acquaintance with it. I can't pretend to have a lot of the kind of detail and data, but it seems to me that is a significant change in the enforcement landscape that's come in relatively recently. And one specific, I mean, the general point is that the working group may wish to kind of consider that as part of its remit and link up with the people who are doing the necessary work on the review. The specific point that I had is that there's an obligation of the regulations for the Secretary of State to maintain an electronic register of moratoria. There's also separately a obligation on a creditor when they're notified of a moratorium to notify the court in relation to any ongoing proceedings. But I don't think there's no
it seems to me that could be quite easily short-circuited potentially. Is if there's already an electronic register, is there any way of joining that up so that it's not reliant on creditors notifying the court and things are more kind of centrally done on that? There may be all sorts of problems with it. It's a kind of thinking on top of.
I don't know.
Well, yes. So we did work with Treasury, the Treasury lead. Yes, and as you say, it's quite a significant policy that allows debtors who have spoken to certified debt advisors to apply for a breathing space. They're then put on a register. The creditor has to check. But yeah, I don't think that would be within the remit of our working group and maybe to feed into any reviews that Treasury does. But we do work closely with the Treasury on that policy.
Right, I think.
We did respond to your. Thank you. We did respond to your consultation. And can I support all the comments that have been made about information? Information is absolutely key. The problem for most small businesses, and bear in mind that we do experience an enormous number of won't pays or we'd like to delay paying as long as possible type of debtors. The problem with the repeated applications is it's very easy, say, for information applications that aren't responded to, and then you have to personally serve. It's possible for a debtor to delay having to provide the information for 2, 3, 4 months before you can take any action at all. And what we've suggested, which I'll just repeat for those that haven't seen what you've seen, is that the information should, as you've suggested, be provided at an earlier stage. At the very latest, if the debtor is in attendance at court when the judgment's entered, they should be required whilst they're at court to complete the relevant information form, or when the judgment order goes out, if they're not at court, that the relevant information form should, as a matter of court order, be required to be completed by them and filed. That then cuts out one of the procedures, cuts out one of the court fees. I'm very much in favour of the comments that have been made about having a single enforcement fee, and what you say about Singapore I think is excellent. But can I just ask you a question beyond that? Are you embracing information in terms of correctly identifying the debtor in claims? Because one of the problems also for some businesses is having to make a Norwich Pharmacal application or take some sort of step like that to identify who has got their money, who is the proprietor of a website or an email address, or who is the proprietor of a bank account, so that they can correctly identify the person against whom they want the judgment. I think there's room for a more streamlined procedure that avoids the rather burdensome Norwich Pharmacal type of application, and we're quite happy to discuss those sort of procedures with you. Is that within your remit?
I don't think my remit is entirely encased in stone. So if it is something that would assist and to move things forward, I would very much welcome talking to you about that. I mean, the difficulty is, of course, is that the court itself is not in a position to get too involved on one side or the other with regard to that. And it may well be that the view would be taken is that the party comes to the court to say, I want to enforce something, I want to get my remedy. It's not for the court to actually assist in you getting the remedy in that sense. But I mean, anything that I think can just makes things clearer for people. And I think the points you make about that immediate obtaining of information, whereas you have a system now where, as you know, parties have to apply to the court, then that's served or it's not served, and you go through the whole rigmarole. And as you say, it takes, I'm amazed it takes 3 to 4 months. I think it sometimes takes much longer than that. And if we can just get rid of that, that would be of assistance to everybody. I agree entirely. I'm going to go to the back of the room if questions are still there. Maura, I think. Absolutely not. Yeah.
Sorry, this is special pleading. My name's Maura McGann. I've just taken over as the judge leading on the liaison network for litigants in person. I've no doubt at all that the working group will obviously consider the position of unrepresented litigants on both sides of enforcement. But can I just make that special plea that it is featured and that somebody has the responsibility I'd be happy to liaise with whoever it is. But it does seem to me that for good or ill, these are people who are caught in the middle of this sort of crossfire, and either because they need the money or they need to pay the money. But then they're obviously going to have to be very much considered as this goes forward. Thank you.
Yeah, no, absolutely agree. And one of the things that we are proposing is that, I mean, it should be done within pre-action protocol, but at all stages, information about advice agencies is given to people. And that, I think you can't repeat it often enough to give people the information, because I think, you know, partly fear, partly just don't want to think about it, means that people might get information and they don't actually use it. And I think repeating it many times throughout. But it's a very good point, of course, that it's not just the people who may be facing an order, it's the people seeking an order who may not be represented, and they need that support. So thank you. We have it well in mind, and even more so now. I'm going to go online because I know there are two people. I think Lucy Anderson, you have your hand up first.
Yes, thanks so much. Hi, everyone. Yes, I did want to raise the particular issue of enforcing consumer law judgments. I mean, I'm not sure to what extent these are where their money, that falls within your remit, but you may be aware that there was a particular problem around particularly judgments against airlines for passenger rights compensation, where some of the airlines did have a presence in the UK, but it was difficult for bailiffs to get to them. And that required the Civil Aviation Authority to intervene. I think the situation is now better. But in consumer law, often we do have refunds or money claims or compensation in circumstances where the company involved may be online, not the type of situation where things need to be served abroad, but the type of situation where they may have a more limited or difficult to access presence in the UK. And then more widely, since I'm here, please, can we have more of a breakdown of types of cases? I know this is a big issue for the MOJ. For consumer lawyers amongst us, simply not being able to have data on county court consumer law cases is really such it hampers our work. Thank you.
No, thank you very much. I think that might be an HMCTS role on the MOJ for data.
Yeah, thank you. Yeah, so the Ministry of Justice under the previous government consulted on including claimant names on the register of judgments. And that was a policy that's thought to help consumers, so consumers who have default judgments, including businesses who've had default judgments made, to find out details about the claimant more quickly. But it's also felt, and we consulted on whether it would help consumer groups and regulators have a better idea of who's using the county court. And this government will be making an announcement about that consultation soon.
Okay, no, but thank you very much for that. All noted. Helen online, you have your hand up.
Hello, yes, can you hear me?
Yes, thank you.
Brilliant.
We can't see you, but we can hear you.
My name's Helen Paczynski and I'm a solicitor at Unison. It may not be within your remit, but I was going to raise about the difficulties with enforcement as a result of employment tribunal judgments. We often have employers failing to pay up and workers needing to give up and getting that enforced. I know in the Employment Rights Bill that's going through at the moment, they're trying to introduce changes via the Fair Work Agency, and that will be to combine the existing enforcement functions of HMRC in terms of national minimum wage and the Employment Agency Standards Inspectorate and Gangmasters and Labour Abuse Authority. So that piece of legislation that's now going through is going to be looking at enforcement in that area. And I just think it's useful to flag that up and to for there to be some sort of link, I suppose, in the work you're doing, because there may be things that come out of that consultation and secondary legislation that's really useful to you or can help you in the work you do that's going through at the moment. So it's just really to flag, it may well be on your radar, but just to flag that to you.
Probably not as well on my radar as it should have been. So that is actually really, really helpful. And I will talk to people about that. So thank you for that. Good. Back in the room. I think I will come to you next. And just I'm pointing at you. I'm sorry.
Guy Baddeley, I'm the designated civil judge for South Yorkshire. 2 points. One, just to flag up a family rule 33.32, enforcement by such means as the court considers appropriate. I don't know whether consideration has been given to carrying that across into civil proceedings as a way of simplifying things. You just apply for enforcement and then a district judge could consider the best way of proceeding. And the second point is just to flag up the unease I feel really about the committal route in enforcement applications. As I think I said in my response, are there no prisons? Are there no workhouses? It's a bit Dickensian, and there may be a better way that may simplify matters. And I know that raises issues of confidentiality, but if you can bypass the debtor having to fill out information as to whether they're working on benefits or have savings, then the whole process could perhaps be much more simple. I don't know what other views are on that, but that's certainly my thoughts on it.
Well, I agree. I think it's an entirely unwieldy process, not good for either side. It doesn't actually create the information or provide the information speedily. And, when you're getting down to the point of saying somebody's going to be committed for contempt for failing to answer a question of the court, you sort of rather failed in the purpose of the whole procedure. And I think that's something that I would hope with proposals we'll make with regard to providing information at an early stage, that then won't be a necessity. That's the way I would like to look at it. Can I come to the front now, because I know you've been waiting patiently just here. Thank you.
Hello, thank you so much. My name is Zakia and I'm here on behalf of the Civil Court Users Association, the CCUA. We've also responded to the consultation. It's actually, I just wanted to mention that most of my questions that I was going to raise or points I was going to raise have been already raised, which are all extremely valid and useful. I just wanted to say for Jodie Berg, I was privileged to attend an HMCTS bailiff the National Bailiff event covering the Midlands on Tuesday. I was invited as a CCUA member to give them a presentation, and I was told at that event that they have invested in health and safety equipment for the bailiffs, and actually the Midlands area is going to get it first. They're going to trial it, so they are putting it at the top of their list for the safety and protection of the bailiffs, because they are at the coalface. And actually some of the horror stories I also heard on the day, I've been in litigation for about 20 years and I was sort of shocked, actually. Nothing really shocks me, but so I just wanted to say there is positives out there. It's a slow burner, but we work quite closely with HMCTS and MOJ in bringing these issues to the forefront. So thank you. So this is all very useful.
Yeah, no, well, thank you very much. And I think we're all very conscious of the fact that the bailiffs and the High Court enforcement officers really are on the front line. Terrible things can happen, but that's good news that things are moving. Yeah. Yes. I'll come back to you first and then go back around the room. Yeah.
No one has said anything yet about information from other government agencies. There is a protocol at the moment, I think, where judges can require information from the land registry as to what properties are registered in a person's name. Are you seriously giving thought? Do you want to tell us anything about thoughts being made within the MOJ as to getting information from DVLA, the Benefits Agency, the Passport Office, and those things, because one of the problems with enforcement is if someone doesn't engage with the court process at all and proves elusive, you have to wait for possibly 6 months for them to establish a profile for a process server or investigator to find them, whereas that information is already known to the government, and it should be possible to develop a protocol that is data protective in order to get that information into the enforcement system.
Well, I think that comes back to the point of pass it back to Freshfields and
Yeah, thanks. I mean, it goes to this point and the confidentiality point, and also, I guess, your point earlier about how what the court's role should be in terms of not sort of taking one side or the other in these disputes. And I think all of these issues have been quite well navigated in Part 4 of the Tribunal Courts and Enforcement Act, which I commend to anyone who's not read it, but it essentially empowers the court. So if you're not familiar with it, the judgment debtor can apply to the court for what's called an information order, and the court then can make departmental information requests of government departments, and then come up with it has to produce an information order itself back to the applicant, it's sort of setting out what the best options are for them. So I think that navigates all of those issues brilliantly, and it's on the statute book, so hooray.
Yeah, it just needs to be put in force.
Yes.
Minor thing. Yeah. Yeah, there certainly has been support from people who have responded to the call for evidence that should come in, and it does seem. I mean, I wasn't aware of it before starting this work, and it seems to me that it is an obvious that we should be making use of, and we will be making recommendations with regard to that. So, I quite like being Fiona Bruce. Would you like to? I don't get paid as much, but you know. That's the end of time.
Thank you very much. If there's time, I'm Daniel Kester. I'm one of the relatively few barristers that works in enforcement law. I think I also submitted a response to the call to evidence.
You did. Very interesting.
One of the thank you. One of the issues that raised in this field is that you have plenty of rules that govern what's meant to happen. But in practice, a debtor facing a writ or warrant of control doesn't have access to the courts, isn't going to be able to enforce the rules. And there isn't really a solution to that, at least not one solution that can be created by introducing new rules. One of the mechanisms I think the courts have created to counterbalance that problem is to say that enforcement agents and High Court enforcement officers are officers of the court, expected to act with integrity and therefore self-regulate at all times. Now I can see that the ECB, who's represented by David Parkin behind me in the room, have taken steps vis-a-vis enforcement agents, but there's something of a lacuna because they haven't taken any steps vis-a-vis High Court enforcement officers, who are currently regulated by this rather strange mechanism of reference to the senior master. I wondered if that was something within scope.
I don't want to talk on David's behalf, who's here, but High Court enforcement firms are accredited by the Enforcement Conduct Board, and pass you back to officers. Yeah. Sorry, David.
It's not really an ECB point.
Yeah.
The ECB regulates agents, but not officers. The question was, what happening for officers?
Indeed, that is strictly true, although, as Tessa says, virtually everything done under the authority of High Court enforcement officers is now accredited by the ECB, and we will have a process for overseeing High Court enforcement work when we introduce our standards, which have just come in, and our complaints and oversight function next year. So anything beyond that, I think, will probably require statutory changes, which I think is probably what the ECB needs to do long term. Exactly what those statutory changes will be is a matter for discussion and no doubt consultation sometime next year.
I've got to turn on. We've come to the end of time. But thank you all very much indeed. Really, really helpful, really interesting. Do please contact me if you have any ideas. I'm willing, open door. So thank you.